Get ready, guys, for dictation at speed of 120 word per minute. Start. This appeal is preferred by the accused appellant challenging the impugned order passed by the High Court at Calcutta in Criminal Revision Application number 156 of 2012 along with an application for quashing of order stop. By this order, the High Court has quashed the charge sheet as only against accused number 3 and accused number 2 while rejecting the application preferred by the accused number 4 stop. The facts germane to the present dispute are summarized as below. Stop. Appellant is the mother of accused number 1 who was allegedly in a love affair with the deceased, and Shubham are the father and elder brother of Babu Das respectively. Stop. All four were initially accused of abetment of suicide and charge sheet under sections 306 read with 34 of the Indian Penal Code 1860. Stop. On 3rd July 2008, an unnatural death came to be registered as the deceased was found dead in the place between the one railway station and another railway station stop. Consequently, an FIR came to be filed by the complainant alleging abetment of suicide against the accused stop. The complainant alleged that the family of the deceased was unhappy with the love affair between Babu Das and the deceased and wanted her to focus on her studies. Stop. On account of this, they requested Babu Das and the other accused persons to help them put an end to the same, which they refused to do. Stop. It is further alleged that the accused person refused to cooperate in finding the deceased when she went missing. Stop. Para. Accordingly, a charge sheet came to be filed against the accused under section 306 and 109 read with 34 of the IPC. Stop. The investigation revealed that about 3 to 4 years before the incident, the love affair between the deceased and Babu Das began. Stop. The parents of the deceased were against the relationship and tried several times to break it off while the accused person encouraged the same. Stop. The post-mortem report disclosed that the death was caused by the effect of injuries on impact due to jumping in front of a train. Stop. Several neighbors were examined and accordingly their statements have come on record. Stop. The witnesses claim that a few days prior to the incident there were altercations between the deceased and Babu Das who refused to marry her. Stop. The allegation against the appellant herein is that she disapproved of her son marrying the deceased and insulted the deceased on account of the same. Stop. After filing of the charge sheet, the accused persons preferred an application for discharge under section 227 of the Code of Criminal Procedure 1973 before the trial court. Stop. The trial court rejected the application. Stop. Para. Aggrieved, the appellant along with others have preferred a revisional and a quashing application before the High Court at Calcutta. Stop. The High Court void the impugned judgment and order dismissed the application preferred by the appellant and refused to entertain the revision petition and the quashing application qua her. Stop. However, the High Court allowed the quashing application preferred by them on the ground that there are no specific allegations against them in the evidence on record. Stop. The operative part of the impugned order is as follows. Stop. So far as the petitioner number 3 is concerned, I find there are prima facie materials against her. Stop. According to the witness, she told by the deceased that when deceased told Babu and his mother, the petitioner number 3, hearing that she could not survive without Babu, they told her that she need not be alive and might die. Stop. Having regard to such statement, there is nothing wrong in framing charge against her for an offence under section 306 IPC. Stop. Para. The primary ground taken by the appellant is that the appellant has committed no act against the deceased so as to instigate her to commit suicide. Stop. In fact, even if the allegations of the appellant disapproving of their marriage are taken to be true, it does not make out an offence under section 306 IPC. Stop. Thus, the appellant states that all allegations are frivolous and she had no role to play in the suicide. Stop. On the other hand, the counsel for the respondent state as well as the respondent complainant submitted that there is a case made out against the appellant under section 306 IPC from the evidence on record, and the High Court has rightly dismissed the petition qua the appellant. Stop. We have carefully perused the record and heard the learned counsels for the appellant, the state, and the complainant. Stop. Section 306 IPC is reproduced below for ready reference. Stop. If any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Stop. We must read section 306 IPC with section 107 IPC, which defines abetment, and it reads as below. Stop. Para. A person abets the doing of a thing who instigates any person to do that thing or engaged with one or more person or persons in any conspiracy for the doing of that thing if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing. Stop. When section 306 IPC is read with section 107 IPC, it is clear that there must be direct or indirect instigation in close proximity to the commission of suicide, along with clear mens rea to abet the commission of suicide. Stop. The appellant has placed strong reliance upon the judgment wherein this court has interpreted sections 306 and 107 IPC together and observed. Stop. Reading these sections together would indicate that there must be either an instigation or an engagement or intentional aid to doing of a thing. Stop. When we apply these three criteria to section 306, it means that all the accused must have encouraged the person to commit suicide or engaged in conspiracy with others to encourage the person to commit suicide or act intentionally to aid the person to commit suicide. Stop. After carefully consideration the facts and the evidence recorded by the courts below and the legal position established through statutory and judicial pronouncement, we are of the view that there is no proximity link between the marital dispute in the marriage of deceased with the appellant and the commission of suicide. Para. The prosecution has failed to collect any evidence to substantiate the allegations against the appellant. Stop. The appellant has not played any active role or any positive or direct act to instigate or aid the deceased in committing suicide. Stop. Neither the statement of the complainant nor that of a colleague of the deceased as recorded by the investigating officer during investigation suggest any kind of instigation by the appellant to abet the commission of suicide. Stop. There is no allegation against the appellant of suggesting the deceased to commit suicide at any time prior to the commission of suicide by her husband. Stop. In Prakash and others versus the state of Maharashtra and another, this court has further interpreted the offence as below. Stop. Section 306 of the IPC has two basic ingredients. First, an act of suicide by one person, and second, the amendment to the said act by another person. Stop. In order to sustain a charge under section 306 of the IPC, it must necessarily be proved that the accused person has contributed to the suicide by the deceased by some direct or indirect act. Stop. Thanks all of you. Now go for typing.